30. Cipatory veil. So what happened to your anticipated before the sessions court?
It was rejected.
Where is the order of rejection? Rejected, yes. Okay,
That a company that is only initiated. September 2021, they did compare with the electricity data from my premises. And after 4 years, they woke up and they suddenly alleging that we just take that away from my house. That electricity.
yes.
My lord, actually, if you don't have the case diary, which section has it? Electricity Act. Electricity Act.
You have deposited the amount.
The electricity board also.
You have deposited the amount. 52,000.
Yes, no, the lordship, actually, I paid the amount from my father. My demise of my petition, my father, 4th of August 2015, my lordship. And 2015, 2021, my father using that electricity that was electricity she was using. And from that part, I have paid the room.
Okay.
During that COVID period, your lordship.
we need to verify,
136(1) Electricity Act is an unbillable offence.
It is a billable offence, lordship, but
You know how 438?
430. They have filed it. Non-billable, not lordship.
Non-billable constitution.
Oh. Okay, then you are appearing for the state.
No, Mr. Acharji is appearing, lordship. Tomorrow, lordship. We need to reach.
Not
Whether
today,
we have
Calcutta.
considered or not.
Not today. Ask him to join. Who is for the state?
For the state one, and I'm ready with the CD.
Have it is filed by the police. They can. POXO.
Always there is a new ground for adjournment, not technically fault, this fault, that fault. These matters were filed in the month of 29th of August, my lord.
Where is the service upon victim by the state?
It was stated, victim copy circular still. The service project. 15-year-old girl. 164 is there, my lord, sufficient material surface.
Wednesday. 19 17 to 19 তারিখ 20 তারিখ তো থার্সডে State.
I heard the statement.
Petitioner has joined the investigation.
Yes, ma'am. And my lord, the documents also seized from This position. The work order and the
Okay,
completion
document.
of work order.
No. This FIR was lodged by the block development officer.
Yes, my lord.
Expert.
The district education officer, my lord. SSM Alipurduar.
This relates to a tender process where it is alleged that a forged document has been relied upon by the petitioner to get the tender in his favor.
Yes, my lord. Thereafter, my lord, he complied the order and this he hand over these documents, my lord. Page 70 and 71.
Oh, this work order is
Work
a forged
order?
one.
Yes, my lord.
This work order is a forged one.
No, my lord. This petitioner handed over these documents, my lord. The work order and the completion, 71 is the completion of the work order.
So
These
then
are not-
where is the question of forging of a document to get the tender?
My lord,
If this particular document is correct,
yes, my lord.
then what has been scrutinized by the block development officer while issuing the work order?
There is no report regarding that, my lord.
In the FIR, which is the document that is alleged to be forged one?
Page, my lord, page 9. Clarification, sir. Sorry,
Page 9.
Page 9, my lord.
This document which he has produced is checked by the investigating
Yes, my
officer?
lord. Yes, my lord. It was seized and it was page 70 and 71, my lord.
What is the report of the investigating officer with
Okay.
regard to these two documents?
Is the. It is only shows that he seized, he videographed and seized these documents.
Oh,
Nothing else.
and appears on behalf of the petitioner. Now, the advocate for the state submits that pursuant to order dated 18th September 2025, the petitioner has joined the investigation and produced documents, handed over the documents, handed over the documents, namely one photocopy of work completion certificate issued by Block Development Officer Suti 2, Dafahat, Murshidabad, and photocopy of number 2, 1 2 कर दो ना, photocopy of letter of work order for construction of 4-unit additional classroom at Shahjadpur, Umarpur High School in Umarpur GP. Addressed to AK Brothers, amounting to rupees what P9 81556. Issued by Block Development Officer Suti 2. Dated 23rd March 2020. Potential justice, the matter is adjourned. Place this matter on Thursday. Appear on Thursday.
Thursday, madam.
Password 15. 16, 18.
Item number 21. These are also matter not affected from kindly direct the state to start to the Item number 23 to 28.
23, for the space. And all this matter, I think Mr. Shiva emphasized there.
Yeah, Devasis's.
My lord, 23, my lord.
Hmm.
195 bottles of cough syrup. Those were recovered from the house of this petitioner. At the time when the recovery was there, the petitioner fled away. But it was his house as per all the 161 statements, and one lady was there. He is the sole accused in this case, my lord. This petitioner.
Oh,
And search and seizure has been made. Definitely he is absconding, so charge sheet could not be submitted.
hmm.
For the FIR. Page D.
My lord, the allegation is that, my lord, 195 bottles of, my lord, cough syrup, amounts to, my lord, contraband article has been recovered from the house of this particular petitioner.
Hmm.
Lord, the last paragraph, page 8.
Yes.
Yes. Lord, may we on 13th of June 2025 at such and such hours, he arrived at the Pushchin Gorinwala and meet with my source to identify the house. As we started ordering the house of Rashidul Mia, one person escaped from the house, who was later identified as Rashidul Mia of such and such address. Then we talked with one lady who introduced herself as Firdausi Khatun, wife of Rashidul Mia of such and such address.
Hmm.
On being asked, initially she denied that there was no contraband articles found in the house and gave different statements at different times, which raised suspicion. Then on interrogated thoroughly, she confessed that there was a contraband cough syrup stored in the house. Then I informed the matter to the Municipal GPS and asked him to arrange an executive magistrate for the purpose of search and seizure. My lord, the entire contraband article allegedly has been seized from the house of my lord Rashidul Mia. My lord, there is no such my lord, information or my lord any my lord with regard to my lord the information of the house. My lord, the house should be situated in particular plot of land, Putian, nothing, my lord. Now, my lord, secondly, my lord, the so far the FIR is concerned, my lord, as soon as my lord, the police, my lord, raiding team, my lord, lord, appeared at the spot, my lord, Rashidul, my lord, fled away. And my lord, they apprehended Firdausi Begum, who happens to be, my lord, the wife of my lord Rashidul Mir. My lord, that lady has not been, my lord, added to the FIR, in presence of whom, my lord, the alleged contraband were seized. My lord, secondly, my lord, I will reiterate, my lord, there is no such information with regard to, my lord, the information of the land, my lord, where, my lord, the house is situated. Nothing. So how could it would be ascertained, my lord, that, my lord, the house of Rashidul Mia, the contraband were, my lord, seized allegedly?
Okay.
Nothing, my lord.
Yes.
Well, the documents are here. I'll just. These are the two documents for electricity connection. And in that house where the contrabands were seized. And another is the Aadhaar card where the address is there, my lord.
Where is this Caesar?
Caesar is in page number 11.
Ashwin.
This Caesar, my lord.
Then the advocate for the petitioner submits that. the FIR does not specify the house of the petitioner. The seizure has been made in presence of the wife of the accused, petitioner. However, the wife has not been arraigned as a accused in the FIR. He seeks for allowing the prayer of the petitioner for anticipatory bail. Opposing such prayer, learned advocate for the state submits that the recovery has been made from the dwelling house of the petitioner. Recovery of what has been recovered? Cough syrup.
195 bottles of cough syrup.
195.
195.
195 bottles of cough syrup from the dwelling house of the petitioner. Here is the case diary. He seeks for dismissal of the application. Here is the case diary, the materials on record. As per the seizure list, the alleged contraband substances have been recovered from the dwelling house of the petitioner. Considering the aforesaid materials and the gravity of the offense, rejecting this.
My lord, one indulgence, my lord, my designation will be APP, my lord, additional.
Learned additional government pleader. Advocate na kare, learned additional government. Next.
For the stating, I'm holding the seat.
Yeah, my lord. 16 kg of my lord opium poppy plant has been recovered allegedly from a my lord field, cultivated plant, my lord. My lord, if your lordship kindly come to the FIR, my lord, page 10.
Here.
My lord, page 10, my lord, the last paragraph. My lord, on inquiry, my lord, your lordship got it. On inquiry, it could be learned that the owner of the said land, Ramesh Bormon, son of such and such, of Petla, such and such address, has expired such and such, and is things on such and such. So the next page, page 11, my lord. After the death of Ramesh Bormon, his three sons divided the inherited land among themselves verbally for their livelihood. My lord, I will here pause, my lord. The FIR specifically indicates, my lord, that my lord, out pertaining to no such, my lord, Khotian or any such documents, my lord, the land has been verbally divided between the deceased, my lord, three sons. Even, my lord, the investigating authority were also not, my lord, sure that, my lord, the land to whom the land particularly belonged. Out of, my lord, surmise, my lord, they have alleged and, my lord, entangled myself, my lord, and specifically indicated, my lord, that the contraband plant, my lord, the narcotic substance were, my lord, cultivated allegedly in my land. My lord, till date, my lord, the land belongs to, my lord, Ramesh Bormon. Yet not it has been divided, it has not been partitioned. So how could, my lord, they have, my lord, ascertained that, my lord, that the land was, my lord, belongs to.
Oh.
My lord, number two,
Then
my
who
lord,
was cultivating? Somebody else.
somebody else, my lord.
Who is that? Who cultivated in your land?
My lord, the land has still not been, my lord, partitioned or divided among the legal heirs of, my lord, my father.
Huh.
And it has been, my lord, indicated in the FIR that out of, my lord, verbally, my lord, they have divided the land between themselves, pertaining to no documents, no partition.
But you are
So
positing
how
that.
it could be ascertained, my lord, that the cultivated land, my lord, belongs to me? It is their suspicion, my lord. My lord, number 2 is that, my lord, 16 kg of, my lord, opium poppy plant. My lord, there is no, my lord, commercial quantity that has been, my lord, indicated in the official gazette with regard to, my lord, opium poppy plant.
Okay.
My lord, charge sheet has been filed. My lord, kindly come to, my lord, the charge sheet, page 70.
Yes.
My lord, paragraph 4. In such a, my lord, whimsical and, my lord, casual manner, my lord, the charge sheet has been filed. My lord, the 4th paragraph. Thereafter, I submitting CA's White Jalpaiguri PS number such and such under section 18 of the NDPS Act. My lord, section 18, my lord, has 3 subclause A, B, C that has not been, my lord, indicated. Even, my lord, the first page, my lord, page 14. My lord, here, my lord, specifically sections that has been, my lord, imputed only section 18. So, my lord, I will reiterate, my lord, again, my lord, that, my lord, the FIR specifically states, my lord, that the land belongs to one, my lord, Ramesh Bormon, who is now, my lord, since deceased. He has passed away. The land has yet not been divided, partitioned. So how could they, my lord, ascertain, my lord, that the cultivated land belongs to me? They have, my lord, indicated in the FIR that the land was divided verbally. That verbal division was not, my lord, done in front of the, my lord, investigating officer. That is their surmise and their, my lord, suspicion.
Okay. Yes.
And, my lord, the land has no, my lord, commercial quantity, my lord. Opium poppy plant has no commercial quantity that has been, my lord, indicated in the, my lord, list.
Small quantity. Okay. Where is the list?
So in the gazette notification, my lord.
এত মোটা বই নিয়ে আসছিস
Opium serial number, my lord, 92.
নিয়ে দে ভাই Not 1 kg to 50 kg. 50 kg is the, if it is a poppy straw. And it's opium,
2.5 kg.
2.5.
2.5 kg is the outer limit.
My lord.
So, my lord, the plan cannot come within the, my lord, the purview of, my
2.5
lord,
So it's
commercial
a
quantity. That green part
16.600.
has to be excluded, my lord.
Okay.
This is the scissor list, my
Cannot,
lord.
that, my lord, in total cannot be quantified, my lord.
The local witnesses,
Hmm.
they have stated that this land belongs to, this is cultivated by this petitioner. Though the Khotian, which is in page number 36, is still in the name of the father of the petitioner who died long back in 9th of November 2007.
My lord, any witness statement.
Only they have that not applied for
Cannot
the,
justify my, my lord, ownership with regard to a land, my lord. It has to be proved on the basis of a, my lord,
and
particular
this is the admitted
plot
fact, my lord.
information.
What my learned friend has stated that it has been divided though not by meets and bounds, but it has been divided. Here is a family settlement. Orally, it has been divided. So regarding the possession of the land, it is admitted fact from them that they are the owner of that land as per the family settlement between the brothers. It may not be partitioned by meets and bounds by way of a registered deed or a partition suit. But thing is that he is admitted that in spite of that, the prosecution was also investigated and they come to a conclusion after taking 161 statement that this land belongs to this petitioner.
My lord, verbally, my lord, a particular quantum of land cannot be, my lord, divided. It has to follow, my lord, certain procedure, my lord. If it is, my lord, on my lord, mutual basis, it must be on, my lord, the plot information or Khutian
Where
must
are
be
the
there, my lord.
statements? Where are the statements?
Statements of page 13, 19, 13, 14, 15, 16 and 38.
Or the entire plant
Hmm.
of a, my lord, opium poppy, my lord, cannot be quantified as a commercial quantity.
Mhm.
The green portion has to be excluded, my lord. It was only a plant, my lord. Consider, my lord, that on my lord, the whimsical basis, my lord, the charge sheet has been filed. My lord, the FIR has been, my lord, lodged.
So what is the total quantity then?
My lord, 16 kg. They have, my lord, the
16 kg, 600 grams.
16 kg, 600 gram plant. That has to be only plant, my lord.
What is the total quantity?
16 kg, 600 gram.
No, you say that the other portion has to be, that should be
My
separated
lord,
from the.
they have quantified, my lord, the entire plant. And after that, my lord, they come to this, my lord, quantity.
Oh,
Before, my lord, destruction.
these all things are matters of trial. Ashun.
But it has not been ascertained that the land belongs to me or
Okay,
not, my lord.
Learned advocate for the petitioner submits that the land over which the alleged cultivation has been undertaken belong to the father, the deceased father of the petitioner, namely Ramesh Chandra Burman. Upon demise, his three sons have, possessing their respective portion on oral settlement. Stop. There are no such partition affected between the legal years of deceased Ramesh Chandra Burman in meets and bounds. Therefore, the case of the prosecution that the petitioner has cultivated the land, petitioner has made opium cultivation is illusory and is not sustainable. The schedule of the Narcotic Drugs and Psychotropic Substances Act 1985, in short NDPS, does not specify the commercial quantity. In the present case, seizure has been made, quantifying 16.65. What is the total amount? 65.
16 kg, 600 gram.
16 kg, 600 grams. Of plant. He seeks for anticipatory bail. Mr. On the contrary, opposing such prayer for anticipatory bail on an additional additional public prosecutor submits that as per the version of the local villages, such cultivation is carried on by the petitioner on the land possessed by him. His expert is Mizal. Here is the case diary materials on it. Admittedly, the land in question belonged to the father of the petitioner. Upon his demise, admitted, it is further not in dispute that upon demise of the father, the petitioner and his two brothers are in possession of their respective portion on oral settlement. The statement of the witnesses shows that such cultivation has been undertaken by the petitioner. Where is the seizure list? There is a seizure of 16.600 kg of the plant with leaves, fruits, and stems. Leaves, fruits, and stems. Stems. Considering such materials and the gravity, I am not inclined to grant anticipatory bail to the petitioner. Dismiss, rejected, and dismiss.
Get no more.
Sure.
Okay.
Next.
Item 25.
এই অমিতাভ এটা 25 লাগলো না? তাতে সুজিত বাবুকে ডিকটেশন দিয়েছি না, ওখানে একটা বলবেন যে absconded from the place of occurrence.
Get from the place
Place of- From his house করে দে, from his house.
From the
House.
house.
এটা কত? 23 তে।
Page number.
23 নম্বর একটা জায়গায় ঢুকিয়ে দেবেন।
So that from the house.
অম্লানজ্যোতি বর্মন। What is this case?
May I manipulate? Kindly come to your page 9. Sure. What's the allegation under section 12 and 17 of the POCSO Act?
Service? Affidavit of service?
Service.
This English translated complaint.
My lord, I am not.
26. Learned advocate for the petitioner. Who is for the state? 26. He is not pressing the application. Seeks to not press the application. In view of the above, the application being CRM within bracket A631 of 2025 stands dismissed as not pressed.
Lord, this is a POXO case, my lord.
Which one?
The next one, 27. my lord.
27. Let go.
27.
27.
Lord, here, my lord, there is the issue of service, my lord. Can it be on Thursday, my lord? I will defend the service.
Who is for the state?
Ram.
Learned advocate for the petitioner seeks accommodation to serve. Complainant victim is a party.
No, my lord.
On the prayer of learned advocate for the petition, leave is granted to implead the victim as a party respondent in the instant application. Learned advocate for the petition directed to cause service upon the de facto complaint victim, de facto complaint / victim, and file affidavit of service on the returnable date. In the meantime, state serve. Which police station?
Bokshirat, man.
Thursday.
My lord, make it Friday, my lord. Bokshirat. Huh? Bokshirat, my lord.
No, Monday.
Why? It is far off.
25 kilometers.
Friday.
Friday.
Friday, I have some.
You have difficulty. Then Monday. Monday kar di.
Monday.
Monday.
My lord, grateful.
Item 28. 28, my lord, the petitioner has been subsequently arrested, my lord. I am not pressing the application.
Learned advocate for the petitioner submits that the petitioner has already been arrested. Huh? And as says the application has become infructuous. In view of the state,
Yes, madam.
in view of the above, the application being CRM A638 of 2025 stands dismissed as being infructuous. State.
Yes, madam.
Peculiar parents. Man made his unfortunate demise at the in-laws place. And Lord, subsequently, the relatives of the wife, they lodged a complaint stating that the husband's family tortured and Lord, abused her daughter. Subsequently, my lord, the wife met her demise. And my lord, 302 was added. As a consequence, my lord,
No, who died? The husband has died.
first the man died, and my lord, the
Man died in the house of the wife.
No, my lord, not in the house of the wife, at his own place.
Okay.
And my lord, the allegation is that the man's family abused the wife because, as per them, she happened to be a witch who, my lord, did some magic on the
We shall take one.
Okay.
And Lord, because of the torture, she subsequently met her demise. And Lord, 302 was added. That as a consequence, Lord, two nephews and Lord, sisters were implicated. Lord, these sisters suffered custody and Lord, they have been granted bail.
Who is this person? Two persons are there.
Yes, sir.
Who are the applicants?
They are, my lord, the nephew of the husband of the man who died early.
My lord, page number 8 to 12.
Lord, before the prosecution submits, Lord, kindly sees the order granting bail to the other accused. At page
That is after arrest.
Yes, my lord, after.
Where is that order? You have annexed?
My lord, page 10, annexure B. Now, this second last paragraph is important. My lord, they were
Irumani.
indirect relatives. But my lord, the petitioners before your
ladies.
lordship are my lord the nephews, distant relatives. As a result of which, my lord, these persons were arrested.
Hmm.
My clients have not been arrested yet. My lord, charge sheet has also been filed.
Very serious allegations, man.
Okay.
Very serious allegations. Witch hunting it, anticipatory bail.
Okay. What is the name of the petition? Munna?
Munna and
Munna,
Sushi.
sorry.
Sushi.
The appearing, their names are appearing in the 161 statements. Man.
Okay, name. Where is the postmortem report?
Postmortem report. 58, my lord. 14 injuries.
58.
58, my lord. Total 14 injuries were found during postmortem.
Ash. The advocate for the petitioner submits that there are no such specific allegations against the petitioners. The co-accused, after arrest, has been granted bail by the trial court, learned trial court. Charge sheet submitted.
Yes.
Upon completion of investigation, charge sheet has been submitted in this case. He seeks for anticipatory bail. Opposing such prayer, learned advocate for the state submits that there are specific allegations of against the petitioners of assaulting the victim, resulting in serious injuries and ultimately death. He seeks for dismissal of the application. Here is the case done, materials on record. The statement of the witnesses recorded under section 161 of the CRPC reveals allegations against the petitioners of assaulting the victim along with others. The post-mortem report shows that page number 45. What did you say? Page number 45.
50.
I've got it. 58.
50.
Reveals 14 injuries to the victim. As per the post-mortem report, the cause death was due to effects of head injury, which is antemortem in nature. Charge sheet. Charge sheet has also been submitted under section 341, 326, 307, 120B, adding section 302 IPC against these petitioners and how many accused are there? 5.
Fine.
And petitioners and 3 others. Considering aforesaid materials and the gravity of the offense. Rejected.
Problem. No.
4.
Not 34 and not present.
34. Didn't records. Who is for the state in 34? I have no doubt about it. 34 to the
34.
none and advocate
What is it?
for the petitioner
34, my lord.
submits that.
Previous occasion they have prayed for time. It is not the first occasion they came and they want to not press.
কি বললো? Submits that the petitioner does not intend to press this application. In view of the above, the application stands dismissed as not pressed.
Not 35.
এটার পরে পাস ওভার 1টা ডাকবেন তো? আছি এখন? Yes.
Case under section 306 of the IPC. These sections, arraigned, my lord, are under the BNS. My lord, I am the, my lord, son of the elder sister of the person deceased. The allegation is that the
Son of the elder sister.
of the deceased. My lord, the allegation is that a man, my lord, committed suicide at his in-laws house. Man's family, my lord, lodged the complaint, and the complaint states that there was a previous torture on the man on the ground of transferring certain plots of land. That is, my lord, the crux of the complaint. And my lord, as a result, the father-in-law, the mother-in-law, the elder sister of the wife, the elder sister's husband, the elder sister's son.
This is the
sister-
petitioner. Petitioner.
Yes, my lord. I am, my lord, the son of the elder sister of the wife,
Okay.
the elder sister-in-law's son. I am, my lord, merely 21 years of age. I have, my lord, no connection because omnibus allegations that all of them, my lord, tortured. I am not the direct in-law. I am a distant relative, my lord. Even my residence is separate.
I should just received the case diary. The cause of death, though the case is started under 306, that is on 103 of BNSS, but death was due to the effect of antemortem hanging, as noted above. So the doctor could not opine whether it was suicidal or homicidal. Investigation is still in progress. This petitioner is accused number 5, FR named. And the statements are there of all of the statements support the case of the prosecution that the petitioner took called the deceased to the house to his in-laws house where he was staying and where he committed where he died, rather to say, and mental and physical pressure and torture, everything was done in the house of in-laws. The statements support the case of the prosecution.
But as of now, there is no case made out of any homicide.
Lordship, the death was due to the effect of antemortem hanging. This is doctor's opinion. So the doctor could not opine whether it was homicidal, suicide, or suicidal. So it is under investigation. Charge sheet had not been submitted. The investigation is still on progress. This is the case diary, Lordship.
So kindly considers my relation, my age.
Now, what is
My
the
personal
allegations
relation
against
is
this
that
petition?
This petitioner, Lordship, the statements Lordship, I apologize because it's not paginated, Lordship.
What you do, Mr. Ganguly, you
Lordship.
go through that. Let me take it up after the recess.
Lordship.
You
Lordship.
go through the case diary and then place your case. Find out what is the specific allegations
Lordship.
against him,
Lordship.
and if there are any such injuries prior to that hanging, is
Lordship.
it noted in the postmortem
Lordship,
any injuries?
I'll submit.
It will pass over again after recess.
Grateful, Lordship.
Next.
Your Lordship, I'm appearing for the de facto complainant in item number 1, Your Lordship. Am I audible, Your Lordship?
Yes.
Yes, Your Lordship, kindly keep this matter tomorrow. I will be physically present before Your Lordship and apprise the court, Your Lordship. Kindly fix this matter tomorrow.
This is POXO.
Yes, Your Lordship.
Where
The
were
mother
you
of
in
the
the
victim.
morning?
Your
Where were
Lordship,
you in the morning when the matter was called on?
Yes, time was short for Your Lordship and subsequently it was passed over, Your Lordship. Kindly make it not today, Your Lordship. I would physically be present before Your Lordship and apprise the court, Your Lordship.
On the prayer of learned advocate for the de facto complainant appearing through virtue state,
I'm ready with the CD, my
you
lord.
are release this matter on day after tomorrow করে দিন কালকে রাখবেন না কিছু জানি না কি day after tomorrow
Deeply obliged, Your Lordship.
Wednesday next shut up.
Thirty-six Lord, the case dates back to the year 2020. Lord, the charge sheet was filed in the month of March 2021. Lord, the fact is that Lord, a lady, she committed suicide, and Lord, the relatives of the lady, Lord, lodged the complaint against the in-laws. That is not the crux. Lord, originally in the complaint, it was so drafted that there was a suspicion of murder.
No, these petitioners are how they are related to.
Yes. I am my lord. Lord, the mother-in-law and my lord, the brother-in-law. And my lord, the brother-in-law's wife.
Three petitioners are there.
Yes. Mother-in-law, brother-in-law, and brother-in-law's wife. My lord, charge sheet, kindly takes up the charge sheet, my lord, page 14. The relevant page is page 14, my lord. I'll read out in the second paragraph. During investigation, I followed up all the line of investigation, visited the PO and examined the available witnesses, recorded their statements under section 161 of the CRPC. During further investigation of the case, I collected the PM report and also examined more witnesses and recorded their statements. During investigation of the case, the prima facie charge under 498A and 304B against the accused persons, Ujjwal Vishwas, Reena Vishwas, Vibhash Vishwas, Tulika Vishwas, has been well established. During investigation and as per statement of witnesses and circumstantial evidences, section 302 IPC is not established. No evidence could not be established against FIR named accused person, none of the victim, and one accused, namely Bimal Gandhi Vishwas, who happened to be the father-in-law, is died on 27/10/2020. Hence, they are excluded from the accused persons list. This will not be crux of the charge sheet. And Lord, one another thing is which is very important, my lord, we have not been shown as absconding from the charge sheet. We had, my lord, during the investigation, we had joined the investigation, we had cooperated. There is no, my lord, reason for our arrest, for our custodial interrogation.
Lordship, in the city, there is nothing that they cooperate with the investigation or during investigation, they are visited with the investigating officer. No such fact. Finding the
If I
city.
see the charge sheet.
No, no,
does
no,
not show
no,
us as
no,
absconding.
no. Non-available case. The life imprisonment,
In
how?
anticipated bail application.
Okay, Lordship.
There are custodial interrogation.
Kindly, please, page number
Primary.
4 and 5, Lordship.
Charge sheet was filed in the month of March 2021. There are 4 years after.
You have been filed.
Yes, sir.
Then order for proclamation has already been issued.
No, that I do not know.
So take that instruction, because if you are proclaimed as an absconder and you are filed in this case, then there is no ground for moving this application. Surrender before the court.
Proclamation has, my lord, so far.
4 years have gone by after filing of the charge sheet. So kindly find out what is the position before the trial court.
My tutor just instructed, my lord, proclamation has not been.
Now that is his
That is not-
instruction. You find out. You also, sir, you find out and inform the court whether any order of proclamation has been issued.
Then takes it.
No, Lordship.
State is directed furnish a report as to whether any order of proclamation has been issued by the learned trial court against this petitioner on the returnable date on Thursday. Thursday.
Bibliop.
Huh? Any order of proclamation has been issued against the petitioner.
Item 37. So item 37, I'm paying for 1 week surgery. The copy has been posted up on the victim girl, but then it has not been received by her. And fix it to give 1 week accommodation. 37. 37.
When you will serve and when the matter will be taken up, filed on 4th September.
4th September, Lordship. Unfortunately, there is some site, it has been already posted.
Where is the affidavit of service?
Lordship, it has not been served by, it has not been received by.
Anyway, if it is not received unserved, then file an affidavit of service so that I can
I will
record
file
that it has
on
not
the
been
next day.
served.
I will file.
When?
On the next day, Lordship.
Then
1 week later.
not today. File the affidavit of service
Right.
tomorrow.
Right.
Wait for the state.
My lord, I am for the state. CD not present, my lord.
Where is your status report? Propose. County submit the defects of agreement.
1 day accommodation, my lord.
None appears. None appears on behalf of the petitioner. Learned advocate for the state seeks accommodation to file status report. Thursday দিন আপনার ঠিক আছে ডেট দিয়ে দেন চলিয়ে
Lordship, Lordship, what has been fallen from the mouth of Lordship? I have gone through the case diary. Lordship, I have folded the statements made under 161 as because no pagination I already submitted. Lordship, Lordship can go through the statements. No particularly any allegation against this petition. It's an omnibus allegation. These are the statements, Lordship. I folded. Kindly, Lordship, for my session, have a look.
He is the
No,
Is
my
this
lord told me
son?
to see all those. Lordship, I have folded it. Yes.
son of the
Omnibus allegation.
sister-in-law.
Yes. This is the trend of 161 recorded. And the PME's Lordship, I have flagged it. The opinion of the doctor, which I have told, is in the bottom. No external injury apart from this. These were the two aspects, my lord, inquired.
This is 306. Charge sheet not yet submitted.
No, lordship, investigation not in progress. Only these six statements and the PM
Any
report.
accused having granted bail?
No, my lord. I'm the first person who has approached any issues for my lord.
Hundred and three is the corresponding to 306.
Yes. 103 1.
Ask. कोर्ट को है कोर्ट Learned advocate for the petitioner submits that the petitioner is the son of the sister-in-law of the deceased, who he committed, he died in which place?
In in-laws house, lordship.
Who died in the in-laws house. There are no such
Let's just child. Let's just child.
allegations as against the petitioner. He seeks for anticipatory bail. Learned advocate for the state. I record opposes such prayer.
Opposite.
your
Opposes.
such prayer. Here is the case diary and the materials on record. There are, upon going through the statement of the witnesses, recorded under section 161, there are no such allegations as against the petitioner. The against no particular allegation, no particular allegation against. The post-mortem report reveals that the death was due to effect of antemortem hanging. In view of the above, I am inclined to grant anticipatory bail to the petitioner in the event of arrest. What a 10,000 with 2 CODs question each, huh? Subject to uh, satisfaction of the arresting officer and compliance of the provisions of 438(2)/482. What is that provision? 482
482
2
Lordship,
of the BNS.
as because the investigation is not completed to meet the IO.
So that is in the 485(2)
But-
itself. It is there that he will join investigation. At Gurudin, the petitioner is directed to join investigation and cooperate with investigating officer. Case directed.
Grateful, Lordship.
ए लिखे दिए ए नेक्स्ट
39 Lordship praying for 1 day accommodation, Lordship, and for the state, CD is not available.
none appears on behalf of the petition. This what are the sections? POXO.
No, NDPS.
The second application. 430. What is in Vishnu Gorman? He has been arrested.
I have no instruction.
Because earlier he filed an application under 439, which was not traced. Subhashish Mishra. Huh? এটা ভুল হয়েছে তো এখানে এ মানে তো অ্যান্টিসিপেটরি বেল নাকি এই যে এ সিআরএম এ মানে তো অ্যান্টিসিপেটরি এটা সিআরএম এ তে 439 টাইপ করেছে কেন কে এটা এখানে 483 করেছে ওটা নট প্রেস করেছে none appears on behalf of the state. A state is represented, none appears on behalf of the petitioner, for the matter is adjourned, this matter. 24th.
24th.
I'm for the state present. I'm for the state.
Petitioner Lordship.
Which item?
Lordship, my landed senior is in
Which item? Which item? Item number?
not today. Item number 10. Praying for what?
39 order has been recorded. It will appear on 24th.
Grateful Lordship.
Huh? None appears. Order होएगा फिर. None appears on behalf of the petitioner. 439. Oxford is there.
Under section 64 and 70 BNS.
What is it corresponding to? The IPC 376. Service has been effected upon the de facto complement. None appears on behalf of the petitioner. State is directed to serve upon the de facto complainant victim. Which police station is this? On Thursday? Is this matter? Thursday.
I think 41.
6 POXO.
Not
Service.
the petitioner, the copy has not been served yet to the victim. And
You have sent. You have sent the copy.
no, if the copy
Well-
has not been served yet, Lordship kindly fix it for Thursday or Friday in the meantime.
Why you have not, sir? An advocate for the petitioner seeks accommodation to serve upon the de facto complainant victim. Let such service be effected upon the de facto complainant by the petitioner. Petition directed to serve, an advocate for the petitioner is directed to serve upon the de facto complainant victim and file affidavit of service on the returnable date. In the meantime, state. এটা কিন্তু ওইটাই থাকবে নিচের কমপ্লেন ফ্রাইডে Second call. Victim. (126) POXO. Service. Where is the affidavit of service? Who is for the state? You are for the state. Pass over again. Advocate for the petitioner. Petitioners. Petitioner. No. Civil নয় ক্রিমিনাল অ্যাডভোকেট বলছে আগে তো তাই করে গেছে গো সাবমিশন নোট করে তো করে An advocate for the petition submits that the petitioner does not intend to press this application in view of the above submission. The application being CRMA 678 of 2025 stands dismissed as not pressed.
I'm for the de facto complainant.
I lost the complaint. It's the way to coverage. Again, the business defects of and thereafter, they lodged this complaint on against me, but on 30 of May 2025. My case was earlier lost and it was registered against them. Thereafter, they lodged this complaint.
Yours one is earlier one.
Well,
You filed the earlier complaint.
But I filed complaint 6th of May 2025. I already annexed. Well, page 8, 9. Page 11 is the state complaint. From 8 to 11, my lost complaint article. On 6th of it. Thereafter, they lost this complaint.
Attacked by the above. This is also the match. কি বলো Yes.
My lord, I have
Yes, for my lord, interrogation.
Huh?
Interrogation is needed in this case.
one thing to be added, my lord.
What is needed?
164 of the victim lady.
Huh.
So my lord, there is a question of threatening there, my lord. First interrogation, my lord.
One more thing to be added, my lord. I am for the de facto complainant, my lord. On 5/9/2022, I lodged one FIR against them, my lord. At that time, this lady was pregnant. They threw stones upon that lady, and at that time also, this is the copy of that complaint, my lord. At that time also, they also threatened this lady to kill, my lord. So firstly, we filed complaint, then all this took place, my lord.
What is the allegation of rape? What is the medical?
Allegation of rape is there, my lord. She was tried to rape, my lord. Attempt is there, lordship. My lord, charge sheet is pending. My lord, other qualities are also there, my lord. So
enmity counter registered against. I fight was complaint earlier, there is every possibility of false implication.
Where is the medical?
Medical is at page number 15.
Cooperatively. I also manage the attendance sheet of my university.
My lord, charge sheet has not yet been submitted, my lord.
Refused.
On that day, I was.
Which is the earliest date of occurrence?
Yes, my lord.
What is the earliest date of occurrence?
The occurrence is on 30th May 2025.
On that day, I was in that university, I was managed the attendance sheet of somewhat contest 12.
How many accused are there?
And others are written, my lord. So charge sheet is yet to be filed, my lord.
Charge sheet has not been filed as yet.
No. They
FIR
have
name,
prayed
how many
for further extension.
How many
of
accused are
20 days.
there?
Yes, my lord.
How many accused are there?
My lord, and others are written, so my lord. It is up to the investigation officers to identify, my lord, who are the other accused persons.
Asun, learned advocate for the petitioner submits that the petitioner has been falsely implicated in this case. There are previous criminal cases initiated between the parties. He seeks for anticipatory bail. Opposing such prayer for bail, learned advocate for the state submits that the investigation is under process and there are prima facie allegation against the petitioner. Learned advocate for de facto complainant submits that in the year 2022, a complaint was lodged against the petitioner for throwing stone on the gate of the petitioner and also of threatening. He seeks for dismissal of the application. Reduce the case and the materials on record. It is not in dispute that there are previous criminal litigations by and between the parties. The victim, in a statement under 164 of the CRPC, alleges of states. Of threatening, rape and theft. The victim has refused to undergo medical examination. Considering the above circumstances, I'm inclined to grant anticipatory bail to the petitioner, subject to তাকে 10,000 to securities to the satisfaction of arresting officer in the event of arrest. And compliance of 485(2) of BNSS disposed of. And give a copy of this complaint.
এটা
My lord, item number 45, kindly keep it on Wednesday, Lord.
Why case date is not there?
Wednesday, because Mr. Arjun Chaudhary is there, my lord, so he's sick, my lord, so he has asked me for adjournment, taking adjournment today.
An advocate for the state seeks accommodation. Please this matter on Wednesday.
Wednesday. Grateful, my lord.
Yes.
Yes.
None appears on behalf of the petitioner. Foxwell is there. You are for the petition. None appears on behalf of the petitioner. State.
Yes, Lord, I am for the state.
State is represented. For ends of justice, the matter is adjourned. List this matter on Thursday. Oh, 98, 307. Okay. You are the advocate for the petitioner submits that the petitioner is the husband. The there are the allegations are omnibus. And the FIR is a result of matrimonial dispute. He seeks for anticipatory bail. State. This shows the state.
Yes, কত নম্বর? সেজন্য time দিচ্ছি। My lord, Mr. Nag is there, Kollol Nag. I think it's in court number 4, my lord.
To pass over. It pass over.
Take time to hand over this. All this is from this.
20? Who has died? Who has died? Aunt. Why 26 then? तो सुलझा होगा। On the prayer learned advocate for the petitioner. Let it go to the next circuit then. कब है next circuit? कब है next
15
circuit?
December. 15 December থেকে from 15 December.
नहीं देरी हो रही है। When you will come? When the learned advocate conducting advocate will come in court?
Either in Jalpaiguri or 25th probably.
No chance definitely. ঠিক আছে 26. 26.
Rather diet from white rather along this complaint and with rather. So then there is parties to be confident system.
Who committed suicide? Brother? Your brother committed suicide due to property dispute between you.
There is a question of and who will be inherited? My father died. Yeah, I mean, the allegation by the Alright.
What is in the affair? In the case diary, what is it?
Yes, sir.
What is there?
Lordship, just received a case date, Lordship, page number 5, 14, 15, Lordship, wants to a statement there are.
Bill.
Postmortem report?
প্রশ্নটা করে doesn't matter, somebody will go.
ঠিক আছে, পেয়ে গেছি। He is the sole accused.
No, Lordship.
She has been enlarged on bail.
That is okay. না না এখানে বলেছে
Where is that order?
ও অ্যানেক্স মানে এটা
Then the advocate for the petitioner submits that the allegations in the FIR relates to family dispute. There are no such circumstances at the instance of the petitioner which led to abatement of suicide. When was the wife was arrested? Wife was arrested. It was prior to filing of the charge sheet. Prior to filing of the charge sheet. দেখো এখানে প্রোক্লেমেশন কিছু হয়েছে নাকি? May. Commitment has been made. Huh? Warrant has been issued against you. Warrant has been issued or not? All are natural consequences. Warrant has been issued. Huh. কি বললাম? Further, upon completion of investigation, charge sheet has been submitted. He seeks for anticipatory bail. Learned advocate for the state opposes such prayer and submits that there are specific allegations. It is the case done in the materials on record. It is found from the statement of the witnesses that save and except of a family dispute and there are no such specific allegations. The allegations appears to be omnibus. In view of the above, I am inclined to grant anticipatory bail. Allowed in the event of arrest, 10,002 securities to the satisfaction of the arresting officer and subject to the compliance of 482(5), no 482(2). তাহলে এ লিখে দিন। ওখানে শ্রীমণি বাবু, the PM report reveals that the death was due to hanging. Due to hanging, effects of hanging. So,
I think deeply.
ওটা একবার দেওয়ার পর কেস ডায়েরিটা উনি আছে, কোথায় গেল লোক?
Case diary.
Who appeared for the state in 49? You kindly have.
Yes. Lordship. Item number 44.
Anti-motor. দিয়ে দিন anti-motor.
বলছে 6 সালে পাচ্ছিল না, কিন্তু কন্টেন্ট হয়েছে পেজ হচ্ছে তোমার 19 থেকে 21
State.
হিয়ারিং হয়েছে না, শুরু
Yes. Only physical assault.
Page 11 and 12 is
One.
FIR was registered by total 12 active person. Some other parties person enjoying a tribute of activity level 8%. For the person is doing application of physical action for a custodial information. I will cooperate with this.
Charge not submitted.
Charge sheet submitted.
Charge sheet.
Lordship, first of all, kindly sees the injury report. In left frontal area, the assault was done. So in the head, with a sharp cutting weapon, so 307 attracts. And this is the statement of the victim, page 23.
Jyotsna.
Yes, Lordship. Better ticket. Page 6 to 8, other statements. Witnesses.
Who lodged the FIR?
Lordship, FIR was lodged by
Husband.
Oh,
Husband. Husband.
Husband. So, Lordship.
Sohidul Haq is the husband.
Husband. 3, Jyotsna BBK, yes. And kindly see, Lordship, page 16 is the bedhead ticket. Though the charge sheet is not annexed herewith, but from the memo of evidence submitted by the police, we find that charge sheet has been submitted. In the first page, Lordship, memo of evidence.
The
First
charge
page,
sheet
okay.
also page 33,
The entire charge sheet is not there.
but it has culminated in charge sheet that has been written.
Lordship.
Learned advocate for the petitioner submits that 9 accused, not 10, out of 10. 10. Out of 12 accused, 8 have been granted anticipatory bail by the learned sessions judge. Which place will be? Sessions judge.
Hometown of the Hillola.
Judge.
কুচবিহার দিয়েছে সেশন জাজ করে দিয়েছো
কুচবিহার
কুচবিহার লর্ডশিপ
The petitioner has been falsely implicated in this case out of. They are the neighbors or family? Out of village disputes.
Allegation of snatching gold chain is also there.
He seeks for anticipatory bail. Now, how many of them filed application for anticipatory before the session? 10 have approached the court. How many have been allowed and how many rejected?
10 accused person preferred, my prayer was turned down, and 8 rest accused were allowed.
10 approached, 9 approached.
9, total 9, 10 approached, but 9 allowed. My prayer was INA. Lordship says page 9. Page 9, last paragraph, in the event of arrest, the accused petitioner number 2 to 10. So petition number 1 was the vice petitioner.
The opposing, he seeks for anticipatory bail. 8 have been granted. 9. ইনি হচ্ছেন 10 নম্বর। হলো opposite such prayer, learned advocate for the state submits that the victim sustained cut injury on left frontal area. There are specific allegations against this petitioner. He seeks for dismissal of the bail application. Sorry, dismissal of the prayer for anticipatory bail. Here is the case and materials on record. It is found that there are specific allegations against this petitioner of assaulting the victim. The victim sustained cut injury over left frontal area and had to be admitted to the hospital. Considering such materials and the nature and gravity of the offense, I am not inclined to allow the prayer for anticipatory bail, hence rejected. Application being CRMA 694 of 20 and dismiss. Next,
51.
47 তো হয়ে গেছে? Only?
Society is 76. I am the husband, my lord. Where before 18 years ago, my lord sold.
18 years.
I still, my lord.
Para. A divorce suit has been filed. Yes.
Charge sheet has been filed. Our statement is page number 6. Our statement is recorded. And you see the background.
See, sustained fracture injuries.
Yes. The statement of it number 6.
What about the other accused?
Yeah.
On bail?
And all are related.
Question. An advocate for the petitioner submits that his marriage was solemnized with the victim 18 years ago. The FIR is the outcome of family dispute. He seeks for anticipatory bail. Opposing such prayer for bail, an advocate for the state submits that the victim sustained injuries which had to be treated as a inpatient. He seeks for dismissal of the application, peruse the case diary and the materials on record. It is found from the medical reports that the victim sustained fracture injuries there is compound fracture injuries in her left hand. And she had to be hospitalized. The statement of the victim reveals serious allegations against the petition. Rejected. Forty-seven. Hindu rights. What are the sections offense?
After my instruction, it will marriage 2011. All other applied to 2025.
Gourango. Husband. What is
Injuries. Not never 307, not that part. Otherwise,
injury report?
page 21.
Arjun. Then advocate for the petitioner submits that the marriage between the petitioner and the victim was solemnized in the year 2011. The FIR has been lodged in July 2025. In between this period, there are no such complaint. The allegations are omnibus. Co-accused have been granted anticipatory bail. Anticipatory bail by the Stations Judge Alipur. Alipurduar, no? Alipurduar. He seeks for and the prayer of the petitioner was rejected. He seeks for anticipatory bail. Opposing such prayer for anticipatory bail, learned advocate for the state submits that there are specific allegations against the petitioners of inflicting torture upon the victim, which resulted in her injury. Seeks for dismissal of the bail anticipatory bail application. Peruse the case and materials on record. The victim in a statement recorded under section 164 of the CRPC obligation stated of assault and assault by the petitioner. Be that as it may, the injury report shows mild swelling of right cheek. Swelling of right cheek. In view of the above, I am inclined to grant anticipatory bail to the petitioner. In the event of arrest, the petitioner allowed. Hence, 10,002 securities to the satisfaction of arresting officer subject to compliance of 482. Next.
And take for day of the flood.
Aye.
Doctor Chaudhary is continuing some holiday. Day after.
Case diary spawn for. This is POXO. POXO. P0. The sole accused or there are other accused also? Other accused have been granted bail.
Counter case he has produced.
No coercive action should be taken.
Yes, sir. No coercive action.
This is arising out of FIR number 58. Counter case diary is
I
available.
have one, this is Jalpaiguri PS case number 58,025.
That is
And she is right on the last commission. The counter case CD was also called for, but I'm holding the counter case CD.
Okay.
Day after tomorrow.
An advocate for this petitioner seeks accommodation. It have witness to the record. State is directed to produce the case diary of FIR number 60 of 2025 on the returnable date. Hmm? It is Sitalkuchi, no? ওইটা করে দিন শীতলকুচি পিএস কেস নাম্বার 60 or 20 এটা 60
But aggregation under section 496 But I have served the lawyer, effect the complaint, but you are not.
The victim is served. Affidavit of service filed on behalf of the petition is taken on record. It is found that service could not be effected upon the de facto complaint victim. State is directed to serve upon the victim যেটা থাকে আমাদের এখানে কি লিগ্যাল সার্ভিসেস কমিটি আছে নাকি জিজ্ঞেস করুন না রেজিস্ট্রারকে ডিরেকশন দিয়ে দিন অ্যাকাউন্ট করুন রেজিস্ট্রার বলে দেবে হ্যাঁ which police station is this
But this Saibganj to
who is for the state Saibganj তাহলে ফ্রাইডেতে কর ফ্রাইডে next
But offense under section 341, 323, 325.
Mr. Bhattacharya is in photo four.
all not today then tomorrow will not be available after 10 minutes ask him to come 325 335 I'll take it ये 3:35 এটা দেবেন
By the coordinate bench.
I've complied with the order passed.
investigation is still on
My lord,
Supplementary charge sheet has.
in the supplementary charge sheet your name has so you never participated in the process of this
No, Lords. After that, Lords, once this order has been passed, thereafter, Lords, have been complying on a weekly basis.
no you being a government official you have not
No, Lords. In fact, I was the complainant. Later on, I have been roped in by way of the charge sheet. The original complaint was preferred by me when I was the joint BDO.
Achha. Then you are not notified that you have been charge sheeted
Never. I came to know, Lords, was the charge sheet was filed, then I was made an.
my lord, as per his submission, he is the whistleblower. And as a protector, he became the destroyer. Now he says sanction was granted in the month of 8th of January 2025 and supplementary charge sheet was filed on 19th March 25. It's a voluminous CD of near about 4,000 pages because it's a long investigation. Government monies, lot of money are involved, near about 1 crore. 1 crore 66 lakh 70,203. Out of them, certain checks were disbursed. And that also amounts to one out of that payment was made disbursement of 1 crore 11 lakhs. Now, in these checks, he was one of the signatory authorities, and his signatures were sent to the handwriting expert, and it was found that it is his signature. So after that, investigation is done by the CID department. So after that, supplementary charge sheet has been filed. Now he has retired from his service. His presence is required, my lord. We have an objection. Has to be interrogated, though we have filed the supplementary charge sheet, but he was absconding for a long time.
I was not absconding, but my name appeared for the first time here on 19th of March 2025.
So,
This is just because it's a voluminous CD. We have made a short note of the CD as per which has been submitted. This has been made by the investigation officer. First page is double same, my lord, it's a double same. Now it starts from the.
Total means there are 15 items, all are on bail. My name appeared in the third supplementary charge sheet. Incident is of 2014.
Can you, Mr. Chakraborty, can you just produce the documents by dint of which this particular report has been prepared by the investigating officers? So those documents kindly please.
It's not what I said, my lord, it's a voluminous report. No, the only
Because-
allegation against me is that I countersigned the checks.
Why did you counter that? For that reason,
The video also signed it. The
so
video
you did
is
not
a-
scrutinize whether you are sending it, who is entitled to that?
Original signatory is the video. Video has never been made an accused person. I am the last accused person in the case. Notes. I retired in 2015.
No.
10 years after that one.
The last page, the exact allegation against him is in the last page of the report.
And was after the order of the coordinate bench, I have been cooperating with the university throughout. Every week, members, I have been going to the department. And they have endorsed it. The CID office.
That is true, but your role has been detailed over here that you have conspired, prepared a false master role of the persons who are not there, and this amount has been transferred.
As per the act, note, the preparation of master role is not my job profile.
Another thing.
That is what is the allegation?
Stated regarding the video and the signatory authority also. Already we have said that requisition for sanction for the video. We'll be signing a supplementary charge sheet against the video also. Once we get the sanction.
Okay.
Without sanction, we cannot.
What is his name?
My name, Milord, is Bhavendra Nath Adhikar.
Video is Sudhanshu Kumar. 95.
It is stated in the report itself.
Yes.
Yeah.
But I will continue to comply with the last order passed by the coordinate bench.
No, we'll dispose of this on merit.
Marshal.
We'll dispose this application on merit.
From my end, there had been no non-cooperation because, in fact, this complaint itself originated from my complaint. In 2014, I was the complainant.
The other person who have been granted bail as a regular bail or anticipatory bail?
5 of them anticipatory bail, 3 post office. These were also granted anticipatory bail. Everyone is on bail.
You have annexed those orders? You have annexed those orders?
Orders are. In fact,
Against them, the allegation is different, my lord. Here what happened? The money came, the fund came, they were supposed to dig ponds. Out of them, only 3 ponds were digged, some were they were not work were not completed, and some were left, nothing, no work was done. But the entire amount was disbursed, my lord. So from here, it is palpably clear that who is the persons behind all this, who has done this. And the persons, the post office has done, only the accounts were opened there. It came to, that's why the anticipatory bail were granted, because their involvement in this case is not so serious. What is against the video and the joint videos?
Within 3 months of the registration of the FIR, page 22 is the anticipatory bail that has been granted to the government officials, by the division bench. Page 22.
22.
Yes, and then, there are other orders by which, anticipatory bail has been granted to all other accused. Everyone is on bail. In some cases, even the lower court has granted the anticipatory bail.
Well, lower court, trial courts.
I am so sorry.
Jurisdictional
The trial. No, that is my mistake. The trial court has granted anticipatory bail also. In total, there are 15 accused, including me. Everyone is on bail.
But you, along with the video, has transferred those amounts.
My lord.
The video has transferred the amount because the video is the original signatory. I happen to be the counter signing. There are 3 persons who need to sign the check. I am one of the person who signed the check. I am a counter signer.
Equally liable. Partnership.
Now show me the case diary, what the relevant portions. Not all, Mr. I think you have to go through that.
My lord, already the.
Only the portion where the supplementary charge sheet is submitted. That portion and relating to the detailed report he has submitted. All those documents
My lord.
against the present petition.
At this 31 minutes, even the trial court has given bail, anticipatory bail. To some of the accused persons. At the first of pages.
This is the charge sheet.
At 32 also, anticipated bail was allowed. By the trial court.
দেখো তো। এটা দিন তো। Sentence starts with during investigation. This is the complicity of this accused. 1432 vouchers were found out by subsequent investigating agency, and it was found that he has got the signature that was sent to the QDB. So I require those documents and the statement of 7 job card holders. Mr. Chakraborty, what I propose is you go back, sit with them and find out only the complicity of this petitioner. Because he says that some of the accused have been granted bail on the day they were produced. He is a signatory. Just after the video he has put his signature, he has got no complicity. But we have to find out what is the complicity of the accused. Just those documents, the 7 job card holders, they have made their statement, how they have got the money. Wednesday. ঠিক আছে. Go through the papers and place those. Mr. On the prayer of the state, list this matter on Wednesday. Mr. Mishra on Wednesday.
can it be on Thursday? Wednesday is the date before the trial.
On Thursday?
Oh, before the CID.
On Thursday. From report, from that page, you will get that. What are the vouchers, those were collected, what was the report? Just annex those. Okay. Chalo, next. Password কোনটা বলো? 55. 54. Who has come? Learned advocate for the state has come.
But offense under
Start with.
Not offense under section 341, 323, section 5, 307, 120B, 34 of the Indian Penal Code. But there is a long-standing land dispute between the parties, Malad. An allegation is that, Malad, see, if I am the accused person, Malad, assaulted the brother of the Malad, informing Malad. Out of 3, Malad, 2 persons granted accessibility bill by the learned session judge. Kindly see page 10 of my application. But I have also prayed for accessibility bill. My prayer has been rejected and other 2 granted pay. As per the order sheet, Malad.
How many accused are there? 3.
Total 3 who are on anti-Semitic bill by the learned session.
Main allegation. Yes.
Kohinoor Bibi and Noor Alam Mia, they are granted anti-Semitic.
What is the nature of injury?
But as per the FIR, the victim was assaulted with a bamboo sticks on the head. As per the.
Then what is the injury?
But I don't know what.
Well, here is the injury report. Cut injury about right side of the forehead. Nature of injury, my lord, simple. But another fracture is there on the right frontal sinus.
But I use proper.
Charge sheet pending. And it's fact that 2 accused are, they have surrendered, they were in bail, but this person is the principal accused.
But I will cooperate to the investigation, not at least condition, Marat. As per the FIR, Marat, all allegations are yes, all.
Where is the statement of the victim?
Statements are there, 161 of page number 7. That is the brother of the victim. Then page 10, that is the victim, my lord. That is very important. Page number 10. And the independent witness, the neighbors witness are also there. It's me.
But I will cooperate to the investigation, but on any condition, Marat.
Is placed.
There's a land dispute between a long-standing land dispute between the parties, Marat. They are the neighbors.
June. An advocate for the petitioner submits that due to long-standing dispute, the petitioner has been falsely implicated in this case. The petitioner, along with two other FIR named accused persons, filed application before the sessions judge. However, the prayer of the petitioner was turned down. He seeks for anticipatory bail. An additional government pleader, additional public prosecutor submits that the nature of injury is simple. However, there is sign of fracture in the right frontal sinus.
The right.
Frontal sinus, SINUS. He seeks for dismissal of the application. You use the case diary and the materials on record. It is found that there are allegations against the petitioner of assaulting the victim. Be that as it may, the injury report, records of simple injury. Though there are signs of fracture of right frontal sinus. There are no material to suggest he was hospitalized. No.
My lord. Yes, he was hospitalized.
Where is that?
Where's the medical? Page 26. Juliana?
CT scan on 13 June. 9 June. Hospitalization হয় না মনে হচ্ছে।
This is Bamonhat Health Center, BP Health Center.
No, was he referred to any subdivisional hospital for hospitalization, or he was left to undergo a CT scan?
Therefore, a CT scan was done. Up to CT scan, madam. Only refer as CT scan.
No hospitalization.
No.
That the victim was hospitalized. In view of the above, I'm inclined to grant anticipatory bail to the petitioner. In the event.
By the take or something.
10,000 to securities subject to compliance of how many 482 to BNSS देखिए नहीं हाँ? सेक्शन लिखे गए 482 482 sub clause 2. Yes. Document.
Service is not completed yet, sir. Kindly keep it on Friday.
Service upon victory not complete. To state service report.
My lord, we have to serve the notice to the victim, my lord.
There was direction on 10th September.
My lord, actually we have not received the CD yet, my lord. Kindly fix it day after tomorrow.
You have sent the notice? No.
Earlier, once it was sent, but the address was incorrect. Therefore, we had to apply for a.
For service, this is pending since POXO is there.
No, Lordship, 69 of PM.
Deception.
On the prayer of learned advocate for the state, release this matter on Wednesday.
Wednesday, my lord.
Grateful.
Wait a minute. Yes.
Allegation is concerned if you're not really taken paid to bill the case number 9. There was there was love affairs between the deceased and the principal accused as a husband of one. After that, the matrimonial discrepancies was there. And out of frustration, she committed suicide by consuming poison.
No, love affairs was there. They were married. Out of love affairs, the marriage culminated in marriage. How many days?
The 7 years of marriage, she committed suicide by consuming
7 months. 304B.
4B. That is 80 of the PNS.
Then your husband.
Petition number 1 is the husband, my lord, and petition number 2 is the mother-in-law, who is an aged person and ailing due to her old age.
What is it?
My lord, the incident occurred within 7 months of marriage, my lord.
Okay.
And the present petitioners are the husband and the mother-in-law of the victim, my lord.
What is there in case diary?
Yes, my lord. Ekটু দিন না দাদা।
Particularly, my lord, I'm praying for facing for application of mother-in-law. He is an old and ailing person,
What is her age?
67.
My lord, page 11, 12, 13 and 14 are the statements of the neighbors. 11 to 14.
The father-in-law is also accused.
Yes, my lord.
He has been granted bail.
No, he is also the petitioner here. That is the petition number 2, my lord.
Father-in-law?
Father-in-law, not paying for rent.
No, he is an accused. No, he has been granted bail.
He has been granted bail or not. He is not under my.
What happened to the father-in-law then? He's absconding.
Not true. But he is not staying with us.
When was the charge sheet filed? Charge sheet.
Investigation is going on, my lord.
Oh.
He is not staying with us, not, I have no idea about it.
And my lord, page 108 is the post-mortem report.
To make the case more serious, the story of double demand has been incorporated.
Seriously.
ये वेनिस रहेगा ना, विक्टिम को नोटिस कर देगा ना, है नहीं है सिटी रहेगी दुनिया नहीं है। तुम्हारा मेरी प्लान से नहीं पता।
Kindly appreciate there is no suicidal note, it is not stated before anything for the concerned medical hospital. Prior to her death, she was admitted as super specialty hospital at Jalpaiguri.
How many days?
1 day. Madam, I am very excused, madam, 5 days. 22nd July 2025, she was admitted and she expired on 27th July 2025. 5 days. 5 days she was admitted as an indoor patient of the super specialty hospital, Jalpaiguri. But she never, so from my instruction goes, she never made the statement before the concerned medical officer. Or not been left in suicidal note indicating this petitioner.
Wait, sir. Wait. Wait. Let me go through. Yes.
Their status partners is enlarged, has been enlarged on Bimala sessions. I have annexed a copy. There is a page of 15. You can also, can you see the last portion? The owner, the lordship will find. Ordering portion.
Why the application for Anjana was not pressed? Why?
There are some technical mistakes about her age and name, and for that reason, I have been instructed to not press the application.
Or you filed both? When did you file this application?
I have filed this application on 18th September 2025.
18th September.
8th September.
8. Hush. An advocate for the petitioner submits that the victim and petitioner number 1 was married to each other out of love affairs. There are no such allegations of any torture on the ground of demand of dowry after the marriage till the death of the victim. The commission of suicide, the petitioners are no way related to the commissioning of suicide by the victim. He seeks for anticipatory bail on behalf of the petitioners. Opposing such prayer for bail, anticipatory bail, learned advocate for the state submits that the victim committed suicide in her matrimonial home within 7 months of marriage. There are allegations of torture against the আচ্ছা ওনার সাবমিশনের পিটিশনের সাবমিশনে একটা বলুন যে one of the co-accused have been granted anticipatory bail by the learned sessions judge. Father-in-law, Parameshwar is the father-in-law. Father-in-law has been granted bail.
There is of torture against the
Petitioners, which culminated into suicide by the victim. Seeks for dismissal of the application. Here is the case done, the materials on record. Petition number 1 is the husband and petition number 2 is the mother-in-law. There are statements of torture and demand of dowry. In view of the presumption in law, I am not inclined to grant bail to petition number 1, the husband of the victim. So far as petition number 2 is concerned, she stands on the same footing as of the father-in-law. The PM rate of 108 no PM. The death is due to, as per the postmortem report, the death is due to effects of poisonous substance, which is antemortem in nature. 10,000 2 square it is. এখানে সাবজেক্ট টু প্রভিশনে মিট দি ইনভেস্টিগেটিং অফিসারও থাকবে না, একটু কন্ডিশন দিয়ে দেবেন। হ্যাঁ, বলে দিচ্ছেন। হ্যাঁ, মহিলা তো কি না যাবে না, মিট করবে কেন?
We did that. 3 is common intention, section 3, subsection 5. Section 80 is done. We did.
ঠিক আছে। Allowed. 1 rejected, 2 allowed.
Great. Thank you.
And 58, my lord, am I audible, my lord?
Yes.
My lord, this is my second application, allegation under section 20B2C and 29 of the NDPS Act.
Yes,
My
yes.
lord, recovery, my lord,
This is second application.
second application. Earlier was not pressed because at that time charge sheet was not submitted.
Mhm.
Recovery, my lord, 209.70 kgs of ganja and charge sheet filed without FSL report. Identity and nature of substance not scientifically proved. And without FSL, my lord, charge sheet is not complete. My lord, though FI names other persons who played away, they have not been charge sheeted in the charge sheet. And no evidence of conscious possession or control, my lord. The petitioner was not present at the time of seizure. At the time of seizure, and mere seizure from the premises not sufficient in absence of linking any evidence. And so far
That
as
is not available
section
at
30,
this time. Charge sheet is not available at this time. Earlier it
When?
was received by after completion of previous circuit, we returned the CD, and thereafter CD has not been. This is the
Will
case of
produce the case diary. It produce the case diary.
209.7 kg of ganja, my lord.
Produce the case diary on the returnable date. When?
Day after tomorrow, my lord.
Of the petitioner.
Is under Kujbihar district.
6. Accommodation to produce the case diary. Please this matter on Wednesday.
mine.
On Wednesday. Yeah.
Get put the
Nine milord I appeal for the petition. Milord, the case pertains to the milord, Godhaland agitation of milord the year 2008. Milord, there was an offshoot of this particular agitation where
my lord, Mr. Arjun Chaudhary engaged in this case for the state. He is not.
I'm on parity. But the other, I'm on parity, milord, the anticipatory bail order is at page 16.
16.
16. 16 milord is three petitioners on the same one.
I have got the Xerox CD, my lord. I can do it. Mr. Chaudhary, Dr. Chaudhary is sick. I have another case pertaining to the same case number. I can do
Today?
it. I can do it. my lord.
Today?
Let this all this matter may be taken up together.
Number 73 is also on the same CD and the same numbers.
Let it be taken up together, my lord.
9 and 7.
এটা না
CRA 703.
না না মোটা সিডিটা নির্মল ছোপা হ্যাঁ
Item number 73.
তোমার নির্মল ছোপা তো ইয়েস ম্যাডাম সেম সিট Pradhannagar PS number 63, তাই তো?
63 of.
Yes, I have got the same city. One of the accused, two of the accused persons have been granted bail, I think.
Not three.
Neeraj Limbu and Neeraj Limbu.
But I'll tell you Lordship what happened. But this agitation had an output where the ex-servicemen of the hills also Milord took out a similar agitation that was called the ex-servicemen Borhalan agitation. And Milord, there was a ruckus which was created. Milord knows very well on that. And Milord, from the spot, 11 persons were arrested. Milord, the day that they were produced, the next day, they were granted bail by the Lord trial. Now, Milord, 1 year later, when the charge sheet was signed, 40 names, Milord, came up with the charge sheet. We have Milord named in the charge sheet subsequent.
You surrender before the court.
Milord, there is no necessity of custodial interrogation. Milord, I'm on parity as well. This Navraj Limbu and others who have been granted bail by this honorable court are on the same footing. 40 persons, Milord, have been named that they were part of this allegation. And Milord, we are all Milord
On that date,
above 70 years.
70 years.
Yes.
By the petition.
Kindly takes up the affidavit Milord, at page 8.
আমাকে একটা ব্রিফের কপি দিয়ে দিস হ্যাঁ তোদের। এটা কি আছে?
2009.
হ্যাঁ।
Lord, everyone is Milord above 70 years of age. They were Milord ex-servicemen of the army Milord. They took out an allegation. There was a Milord knows very well what happened.
इस नेम
on that-
नेम क्या
on
है
that
इसका?
day.
इसका पिटिशन का नाम क्या है?
There is no need for custodial interrogation. Milord. Also, we are on time.
This person who have been granted bail is under serial number.
Milord, serial number. Charge sheeted serial number. Milord.
তোর নামটা কি একটু বলবি?
First one who has been granted bail.
Huh?
First person Milord is Navraj Limbu. Serial number
24. The 161 straight back.
24 now. Charge sheet.
Thirty-four.
34.
Nirmal Supais,
Navraj Limbu is 30. Thereafter, Milord Man Bahadur Bista. He is Milord 35. And Milord Lalit Bahadur Limbu, Milord, he is 36. These three persons, Milord, have been granted bail by this honorable. And Milord, the 11 persons who were arrested from the spot were Milord granted bail on the next day of production.
B.S. Rai. 5.
তোর এই পিটিশনের নামটা কি রে?
Bhatta Singh Rai.
ভট্টা সিং।
Maniraj Rai, Prem Bahadur Chhetri.
আস্তে আস্তে বল অনেকগুলো নাম আছে কি? ভট্টা সিং রাই,
Maniraj Rai. Bahadur Chhetri.
তাই বলি।
Ramesh Ale or Dilwan.
ভট্টা সিং এর নামটা আছে 161 এ।
নাম সবারই আছে।
What happened that any process under 82 has been issued?
No, if you always inquiring about proclamation, no problem.
There is a judgment of Honorable Supreme Court referred in the subsequent rejection order
Yes, ma'am. I see.
by the sessions judge. You produce a copy of that order and give it to Mr. Vishwas.
No,
On 25th July, this order, this court granted bail to two accused persons.
Yes.
Anticipatory bail. Anticipatory bail was prayed before the sessions judge. On 28 July 2025, sessions judge has rejected the application to be not maintainable, citing a decision of Honorable Supreme Court in SLP 139.
Our Lord, government district judge of Darjeeling, Lord. Lord district judge has a view that once a charge sheet is filed, anticipatory bail applications become non-maintainable. That is an order, my lord, which our Lord district judge, refers to in every case. That is a prevalent view that he has taken, my lord. And that has only been, my lord.
In my MOE also, my lord, there is no reflection of WPA, there is a reflection of WPA, WA, not WPA. Unless and until there is a WPA, my lord, the right to anticipatory bail can be exercised. Once WPA is issued, you cannot file an application for anticipatory bail. That is the law. Since 2012, that the Lavesa judgment came, thereafter that is the law.
After filing of the accused, there is no question of any anticipatory bail.
No. Once proclamation is issued, if he is a proclaimed offender, he is not entitled to get the extraordinary remedy.
So what is the
After setting aside of that order,
what is the ratio in 13956 of the anticipatory? He says that anticipatory bail is not maintainable in law since the accused are absconding or obstructing warrant execution. Because it is correct that filing of the charge sheet leads to all this absconsion and then obstructing warrant execution. What is the ratio in that SLP?
Lordship, your lordship takes up my application, item 73, and annex the entire orders in it. So there is no such proclamation and should be in favor of this case petition.
Take 73 to
And, your lordship, take my application. In page number 18, 19 and 20, there is an order of the learned CJM Darjeeling. The bail order of the learned CJM Darjeeling, wherein it has been stated as there was already peace talks between the state government and this accused petitioner, these accused petitioner is enlarged into. There was already a peace talks going on between the state, the governor and the accused.
Whatever that is outside the ambit of the technical aspect and the provisions of CRPC, you have to come within that ambit. If a talk of peace is going on and the accused have been filed, then will the anticipatory bail lie?
No proclamation.
There is talk of peace and all these are.
I don't think the maintainability point has not been rightly decided by the Narayan district judge. The law is very clear, madam. Until and unless there is WPA, the 438 application is applicable. There are subsequent judgments, my lord, which says that even if proclamation is issued, my lord, if the order suffers from any inherent lacuna or any inherent lacuna, in that case, the anticipatory bail can be applied after setting aside of that order. Usual practice is that they come in such cases, they file a revisional application, get it set aside, and then come for anticipatory bail. So I don't think this has been rightly decided, my lord. The law is very clear and well settled. Until and unless WPA, a proclaimed offender, cannot get, that is the law.
Lord, with due respect to the Lord district judge, Lord Bhubat Singh Silpia, Lord Sushila Agarwal has settled the law with regard to anticipatory bail. The view that he has taken is not, to my limited understanding, is not the right view. Just because charge sheet has been filed, that cannot be a ground for refusing anticipatory. Sushila Agarwal says that till the time that the threat of arrest remains, even after filing of charge sheet, you can pray for anticipatory. You can agitate below section 430. That is not the settled law.
Sushila Agarwal says that there is no need for surrender. A notice will be issued at the conclusion of investigation.
That is regular bail.
No, anticipatory.
Anticipatory bail.
Anticipatory bail is given, but that amounts to a regular bail once it is allowed, because on merits this is being allowed.
Yes, ma'am.
And there were earlier orders being passed that you surrender on such and such within such and such period, and again seek for regular bail. This was the direction what you used to be.
The usual, previously it was there, the CD, the chief judicial magistrate used to call for the CD, and thereafter, after producing the CD, bail was confirmed. That was when we practiced back in 15 years back, this was the rule. In 2012, things started changing.
So they stand on the same footing as of the other.
Yes, ma'am. in both the cases. But I will be formally objecting it. Since there is parity, I have to admit that there is parity. I cannot go beyond the constitutional doctrine, but still it was an assault on the police officers. So I must raise my strong objection on this.
Okay. Awesome. Case diary is there?
Yes, ma'am.
Okay. 59. Mr. Roy, your application is 59. Your is 59.
He's ghost, Roy is junior.
Oh. Sorry. Moyonk is your junior.
No, that as Shakespeare had said, what's it on it?
An advocate for the petitioners submit that the present case has resulted during an agitation which took place in the year 2008. How many accused are there?
Not 41.
And 41 persons have been named in the FIR. Stop. The persons who were arrested on the date of incident were granted bail. Already after completion of investigation, charge sheet has been submitted. Who accused have been granted anticipatory bail by this honorable court in CRM within bracket A 515 of 2025. The present petitioner stands on the same footing. He seeks for grant of anticipatory bail in favor of the petitioners. Mr. Aniruddha Vishwas, learned, you are additional, no, learned advocate for the state, submits that, opposing the prayer for bail submits that, in the said incident, the petitioners assaulted the police personnel. He seeks for dismissal of the bail application, anticipatory bail application. Here use the case diary and the materials on record. এখানে হচ্ছে নির্মল নির্মল is in charge sheet. Nirmal Sub by serial number 30.
Nirmal Subha is 13.
Nirmal Sub. And yours is serial numbers 5 are there, no?
Yes. Here,
Give the serial number. One is Bharti Singh Rai.
Bharta Singh Rai is
Bharta Singh Rai, 27.
27.
Mani Raj Rai,
Maniraj Rai is 16.
yes, 16. Prem Bahadur Chetri,
Milord Prem Bahadur Chetri, thereafter 17.
16.
7.
Prem Bahadur, yes. Ramesh Ali,
Ramesh Ale, Milord 42. Milord, small correction, Milord 42 accused.
ওখানে 42 হবে, 41 বলেছেন, 42. দিল কুমার গুরু,
18.
Hmm?
Serial number 18.
18. বলো
Here is the material, sir.
আচ্ছা it is found that upon completion of investigation, charge sheet has been submitted in this case. two of the accused persons, namely Nauraj Limbu and which is the other one? Nauraj Limbu,
Navraj Limbu,
who were granted anticipated by this court.
yes, Navraj Limbu, Man Bahadur Bista, and my lord Lalit Bahadur Limbu, 34, 35 and 36.
34, 35 and 36. Nauraj Limbu, Man Bahadur Birsa and Lalit Bahadur
Limbu.
Limbu were granted bail in CRM A 515 of 2025. The present petitioners stands on the same footing. Accordingly, in the event of arrest, the petitioners একটাতে petitioner করবেন যেটাতে 73 73 is a petitioner and 70 আর ওনারটা যে petitioner 59 টা in the event of arrest, the petitioner be enlarged on bail upon furnishing bond of rupees 10,000 with one surety to the satisfaction of arresting officer and also subject to conditions as laid down under section 482 of the BNSS. And on further condition, the petitions appear on every date before the jurisdictional court on and from the date fixed for appearance of the accused. And in default, the jurisdictional court will pass appropriate order to secure the presence of the petitioners in court, including cancelling the anticipatory bail granted without reference to this court. Disposed of. Allowed. Correct?